on the slopes of Diamond Head. This is Kapiolani Community College. Kulia Ikanu'u, strive for the highest.
Aloha and welcome to Business Law 200. I'm Ben Carroll. As you know, we start out our sessions by doing a quick review of what we had the time before, and then we'll get into some new material. So let's take a look at our review, see how much you recall from our last session. Okay, we have where does our law come from and what is your understanding of the common law? Okay, where does our law come from? You'll recall that we are constitutionally based, so we look to our Constitution. We'll look both to our federal Constitution and our state Constitution. Constitution provides the different branches of government and the powers, and it delegates to the legislature the ability to make laws, to make statutes. And in turn, the legislature can delegate some of their power to administrative departments and agencies, and so they can give us rules and regulations. And we typically refer to those as administrative rules and regulations and the whole area as administrative law. Then we have the third branch, the judiciary, and that's our court system. The Supreme Court is set up by the Constitution, and the other courts are established through statutes. And the courts give us the case law. So they issue decisions, they interpret and apply the law. And then underlying all this, we have the common law. And you recall that the common law was traditionally oral, but has now been incorporated often into our statutes and appears regularly in our case law. So in Hawaii, our initial statutes indicate that all of these areas are going to be where our law comes from. And we also are going to look in our state to some of the uniquely Hawaiian areas that developed even prior to becoming part of the United States. So we talked a little bit about there are some beach access issues. There's certain ways we deal with family. There's some things that are uniquely Hawaiian that have also come into our law. And same is true of other states. We talked a little bit about the Spanish influence in the southwestern states. Certainly the French influence, the Napoleonic or civil code background for Louisiana. Okay, now common law. What exactly is common law? Again, this is the law that came from England. So we find common law in the British possessions, and there's certain features to that. And the main one really is that the importance of the courts is paramount. So we can also refer to this area as judge-made law or case law. Is kind of a quick and dirty description of what common law is. Okay, so what type of law comes from each branch of government? And do the courts make law? Isn't that the legislative function? Okay, well, again, the executive typically will give us administrative rules and regulations. So that comes from the departments and agencies. There are kind of rare instances when the executive himself or herself can make law. And this is a little bit of a footnote. These would be executive orders. And executive orders come directly from the executive. And typically nowadays, these would be an emergency situation. So you would have an executive order, for example, when a hurricane or other natural disaster required quick action, not enough time to go to the legislature or other lawmaking types. So the executive in that instance may issue executive orders. Okay. Now again, some of these can be pretty important. Actually, it was an executive order from President Truman that first integrated the armed forces in World War II. Truman thought if we're fighting the Nazis, race-based discrimination, it's kind of strange that we have separate black and white, companies in the military. So he issued an executive order that changed that. And this obviously predated by a couple decades when integration happened in the rest of the country. So executive orders can be kind of critical. But again, happens mostly nowadays as a part of an emergency. Okay, the legislature gives us statutes, and that's typically what we think of when we think of making law, is they pass statutes, the people's representatives, Senate or House, passes our laws. And then finally we look at the judiciary. And many people say, well, the judiciary does not make law, shouldn't make law, and so you hear discussions about whether the court is activist or not, whether they are getting into an area that should be reserved for the legislature. So typically we will say that the judiciary interprets and applies the law. However, if you can declare something unconstitutional, in other words, you can make a law go away, maybe we're quibbling to say whether or not the judiciary makes law. So I'll probably use that terminology that we get law from all three of the branches. Okay. What is a precedent, also known as binding authority or stare decisis, and how do the courts use this? Okay, again, this is a feature of the common law. We rely on courts to interpret the statutes and other law that has come before. So over time, we develop traditions where we follow what the courts have done previously. Now, originally, again, this was kind of oral, and then we had case reporting starting where we would get reporters that gathered together all the cases. And this obviously would make it easier for a judge to see what had gone on before. Previously, you might get these reports in a variety of strange ways. They might be reported in the newspaper. Different people might report them different ways. And so it was kind of a great advance in our common law system when these started becoming regularly reported in books, consistently done, certain standards, that sort of thing. And we'll talk a little bit more about that when we talk about how to interpret cases. But we now receive our cases, appellate cases, in reporters, and so we can use those to determine what goes on before. So what's the benefit of precedent of following what we've done before? Well, obviously that gives us predictability. We're able to determine, to plan, to see what's going to happen in these situations because we've had the situation occur and the court has said how the law applies. And so this is useful to us in planning and making sure we stay out of trouble, that sort of thing. It also gives us a sense of fairness. If one judge does it that way, we would hope another judge would apply it the same way. Okay, now again, the courts have to follow higher courts, and we'll talk about court structure today. They don't have to follow necessarily a court on the same level. But when we talk about this, we're talking about following the high court, and we will continue to do that until the high court changes a ruling. And again, that does happen. On occasion, the court will overrule prior decisions based on either changes that have happened or reappraisal of what the appropriate law is. But it does give us some stability, and that's a good thing in general. Okay. What are some of the distinctive features of American law? And what do we mean when we say that the United States has 52 different court systems? Okay, well, some of the things in our common law system we obviously share with other former British possessions and with Britain. So when we talked about the adversary system, we talk about where we have two sides to an issue and both sides present their issue strongly, and out of that, the decision maker, either the judge or the jury, whoever, gets the best of both sides, and they use this to make a decision as to what the appropriate outcome is. But the idea being that we have competing sides, each one championing their approach, and somehow out of this it gives us the best of both sides, and so we use that. Again, this is different from other civil law areas. The Napoleonic Code is more of an administrative proceeding. It doesn't have that sense of a battle. Okay. Another feature of common law is the civil jury system we talked about. Most countries around the world do not have juries for civil matters. And of course, in the United States, we do. And these are features that we do share with other common law areas. Now, there are two places where our American system is rather different. Okay. One of those is our judicial review. So, as we indicated, the Constitution is the fount of all our law. So, the court has developed the ability to declare something unconstitutional. And the purists will look back and say, well, that's not in the Constitution. Where did the right for the Supreme Court to overrule, so to speak, the legislature or Congress occur? And again, this developed, the court itself in Marbury versus Madison in the 1700s made this determination, and so 1800s. And so since then, it's been a done deal. So even though people argue whether or not this is an appropriate way of doing things, it's there. So that's what we have. And again, the other area is the federalism. So when we talk about having 52 different court systems, that's because of federalism, which means that each state has its own government, has its own court system, as well as District of Columbia, and then each state is also part of the federal court system. So each state is going to have two side-by-side court systems to handle different matters, which gives us 52 for the entire United States. Okay, some major differences between civil cases and criminal cases, and can we have a single situation which involve both civil and criminal law? Okay, so I hope you had a chance to look at the chart on the website as well. Quite a few differences between criminal and civil law. We'll just touch on a few, and please review that outline for additional ones. Main thing is the parties involved. So in a criminal case, if somebody has been injured, that is considered to be an injury to the society as a whole. So the criminal, by doing a criminal act, has violated everybody's rights. And so a criminal case is brought by the government. So you have State of Hawaii versus bad actor, or you have United States of America versus criminal. So it's society as a whole that is bringing the action. Now, in a regular civil case, it's an individual or an entity. So it's between persons and groups or entities that are defining their rights that have been injured, etc. So that's a major distinction. A second major distinction is what the penalty is. So if you commit a crime, the possibility is that you will be incarcerated for serious crimes. This does not happen on the civil side. A couple hundred years ago, you might have gone to debtor's prison. Not going to happen now. So prison is a feature that happens on the criminal side. And in some states, there is also the death penalty, kind of the ultimate penalty. Not true in Hawaii, except certain federal crimes have the death penalty. So it's possible that someone in Hawaii on the federal side could have the death penalty, but the state does not have a death penalty. Both sides are going to have money involved. So money is going to be a remedy both sides. Criminal side, it's going to be fines paid to the state or restitution paid to somebody that you've injured. And on the civil side, we call it damages. We'll talk more about that as well. Finally, civil side the court can tell you to do something or not do something. That's called injunctive relief. And you've probably heard of temporary restraining orders where the court can tell you what to do or not to do. Okay. Again, whole lot of differences, more constitutional protections for the criminal side than civil side. Last one I'll leave you with is burden of proof. We talked about this a little bit when we talked about acts that are both crime and civil actions. And the case we used was the O.J. Simpson case, charged with murder on the criminal side and charged with wrongful death on the civil side. So the same incident spawned both of these lawsuits. And the results we had were that he was found not guilty on the criminal side, but was found liable on the civil side. So in one instance, it was found that a killing had not been proved, and on the other side, it was found that killing had been proved. So why the difference? 100-plus books written on this, but one of the easy explanations is the burden of proof is different. So it's harder to prove a criminal case. and we have to prove that beyond a reasonable doubt. And essentially that means we can't think of any other real explanation. On the civil side, we have to prove preponderance of the evidence, and that simply means more likely than not. Okay, so there's not percentages involved, but more likely than not means 50+%. Okay, so again, major differences, but again, it'll be important later on when we start talking about substantive areas of the law to know that something can be both a crime and can also be part of the civil side. Okay, so what are we going to look at today? We're going to look briefly at court structure. We're going to look at what jurisdiction and venue is, and it's going to apply, since we have two court systems, it's going to apply both federal and state. We're going to look a little bit about some differences in cases that involve the government. And finally, we'll talk a little bit about differences between substantive and procedural law. Okay, so the federal court structure. You can see we have U.S. Supreme Court, Circuit Court of Appeals, U.S. District Court, which we consider to be our trial court, and also various specialized courts. So this is the system that appears in every state. Every state is part of the federal system. So again, at the top, United States Supreme Court. We have U.S. Courts of Appeal. There are 12 of those. Hawaii is in the Ninth Circuit. And we have U.S. District Courts. So there's 94 district courts, and they have a bankruptcy court as part of them. And then there's some various specialized courts. So let's talk a little bit about how the federal court system works. In a few minutes, we'll look at what kind of cases are handled on the federal side. But we typically hear about the U.S. Supreme Court, and of course the major function of the U.S. Supreme Court is to handle appeals from the U.S. courts, and that's where we typically hear about the constitutional issues, because they're the final arbiter of whether something is or is not constitutional. So, but if we start at the other end, we start at the U.S. District Courts. Each state has at least one district court, and again, these are based on the size of the states. So Hawaii has a single district. So we have a United States District Court for the District of Hawaii. That covers the entire state. Other states may have more. So you'll have a Southern District, Northern District, Central District, East and West. So larger states like California, Texas, and populous states, New York, Ohio, etc., will have a number of districts. And so if you have a federal case, you will need to go to wherever your district court is. And obviously a lot fewer of those than there would be of the state courts. And as we'll see later, that's because they only handle certain limited matters in federal court. Okay, so that's the first level. That's where you would have your trial if you have a federal matter. And if you lose at trial, that's where you presented your evidence, the judge or jury has ruled, then you would appeal to the Circuit Court of Appeals. Okay, and the Circuit Courts of Appeals cover a geographical area, and Hawaii is in the Ninth Circuit. So we are in the same area as California, Pacific Northwest, Arizona, etc. And so our appeals would go to that particular Circuit Court of Appeals. And if we follow the procedures, we have a right to appeal. So if we do file the proper paperwork, we have a right to take our case to that first level, to the Court of Appeals. And then they will rule on that. After that, if we're still unhappy, you occasionally hear people say, I'm going to take this all the way to the Supreme Court. Well, good luck with that, because you can only go to the U.S. Supreme Court if they want you to come visit. Okay? So you have to ask permission to go from the appellate court, the Court of Appeals, to the Supreme Court. And they only take a small percentage of the cases. So it's kind of the court that says no. They will only take cases they feel need to be taken up to be reviewed by the Supreme Court. So, well, we'll have the little lawyer come and give us a Latin word, because we only bring him on when we have something we need to cover in Latin. The application we make to the Supreme Court to ask them to look at our case is called a writ of certiorari. Okay, now you can see why we need somebody to translate for that. Most of our lawyers don't even use the word certiorari. We talk about cert, C-E-R-T. So we ask for cert, and that's asking permission to take our case up to the Supreme Court. Okay. Now, the state system is going to look very, very similar to this. Okay, so we have a Supreme Court, we also have an Intermediate Court of Appeals, and we have a Circuit Court, which is our main trial court. But you can see we have a couple other levels. So we also have District Court, which includes regular claims and small claims. So when we look in a few minutes at actually what is covered by the state and federal court system, you'll see that the federal courts don't deal with the smaller kind of matters. So we do have an extra level here. And small claims court, actually, you can go without an attorney. So this is for minor kinds of claims where it wouldn't be worth your while to be involved with an attorney. So the small claims handles that. Okay, and we've referred to, in both these instances, we've referred to the main trial court. So what do we mean when we say the main trial court? Well, we'll be looking at this in the future, but what we're talking about is a court which allows you to have a jury. So certain matters you are entitled to a jury. Part of this is in the Constitution, the rest is in the statutes, and we'll look at that. But you're not entitled to a jury for everything. So if you're unfortunate enough to have gone in for a traffic ticket and you request a jury, not going to happen. But in certain instances, you are entitled to a jury, and so that's what we would consider to be the main trial court. So in the federal system, it's going to be the U.S. District Court, and in Hawaii, it's going to be our Circuit Court. Now, other states may have similar names. Our courts, as you can see, pretty much mirror the names of the federal courts, with the Supreme Court, Court of Appeals, and then a Circuit Court. But the court may be called, in other places, county courts. It may be called different things. And in actuality, I believe in New York, the Supreme Court is not the highest court. They have a superior court or a different name. But once you understand the basic structure, most of them are quite similar in that they will have a trial court level, most will have an intermediate level for appeals, and finally they will have a Supreme Court, the highest court. And a fair number will have the same procedure where going from the first appellate level to the highest level requires permission. And most of those will be using the word we talked about, cert, to ask for that highest review. So again, if you understand the structure and you're dealing with the laws of another state or the court structure of another state, you will see some have criminal court of appeals separate from civil court of appeals, that sort of thing. But again, those basic levels are going to be very, very similar. Okay, so again, if we're comparing the state structure with the federal structure, you can see that these are both set up by statute. There are both judicial districts. And the reason is that we want to have our cases heard kind of close to home. So there are different districts. Hawaii, in the federal system, is a single district, but our state court has various circuits, so it has various divisions. State court has various additional levels, as we talked about. It has some courts to deal with smaller matters. And also, the state court has much broader jurisdiction, and we'll be talking about that in a minute. But federal courts are exclusive. They handle only certain kinds of cases, and once we've figured out what those are, we can pretty much say everything else is going to be handled in the state court. So most of our matters, both personally and in business, are probably going to be handled in the state court, except for some exceptions if we bring ourselves within the federal area. Okay, so jurisdiction, what is it? Well, it's where to file, what's the proper court. We're talking generally about the power and authority of a court to hear a case. And as indicated, first question we often will ask is this going to be federal or state? Because again, we have those two court systems operating in our state. Okay, so where to file? We need to decide what kind of case we have, who's involved. we'll be looking at various criteria. It's almost like the old newspaper reporter idea that who, what, when, where, how, why. And so we'll be looking at that when we decide that we have a case. If we have a matter that we think is going to involve litigation, needs to go to court, we'll be looking at all of those various factors to determine where we're going to file our case. And we're going to call that jurisdiction because we need to go to a court that has jurisdiction, in other words, has power or authority over the matter. Okay, so as we talked about, the Supreme Court has its jurisdiction indicated in the Constitution. So in the original setting up of the structure of government, we know what the Supreme Court is meant to handle. And then Congress for the federal system or the legislature for the state system will indicate the powers and authorities of the various lower courts that fit into the system. So we do have constitutional authority for our Supreme Courts and statutes that set out what types of cases, the amounts involved, etc., for our other cases. Okay, so jurisdiction is going to be limited in various different ways. So certain types of cases will have to be brought in certain courts. They're going to cover certain physical areas. We're going to be concerned about the value of the case. And we may have specialty courts that deal with certain types of cases. So we may want some expertise in an area, so this court will only handle a particular kind of matter. One of the examples might be family court, which operates quite differently in a number of ways from our regular court. We won't get heavy into that, but for example, most court cases are open to the public. So prior to TV, people would go down and watch the court. It was kind of the drama, the melodrama that was happening, and there would be court watchers, and they'd just go down and watch a trial. And you could watch criminal trials, civil trials, any kind of trials. But for the most part, intimate family matters were not open to the public. So even though it's a court case, it is handled privately. So if you have divorces, adoptions, that sort of thing, then you don't have a peanut gallery. People can't come in and watch your private affairs. So that's just one of the differences. But there are specialty courts that will handle certain kinds of matters. Okay, so what are some of the limits, some of the factors that we consider when we're looking at jurisdiction? Well, we talk about original jurisdiction and appellate jurisdiction. Okay, so original jurisdiction means that the case originates or it starts in that court. So when we're talking about a trial court, obviously that's where we would file our lawsuit. We'll file it in the trial court. So it originates, it starts in that court. On the other hand, appellate jurisdiction means we already have some kind of decision and we are appealing a decision. So we go to an original court with original jurisdiction, the trial court, we get a decision, a judgment, we don't like it, we appeal to an appellate court. So that's the distinction between original and appellate. The courts operate in rather different ways. If they are in a court with original jurisdiction, then they're hearing the matter for the first time, they are receiving evidence, witnesses, documents, various kinds of exhibits. That would be where a jury's involved. It's live. This is what you see on TV in the movies. This is the kind of hearings that we're used to seeing. So it's the action. That's what the trial is about. And then we get a decision. Now, when it goes to the appellate level, this is all in writing. Okay, so on the appellate level, when an appellate court is reviewing, there's not a bunch of people presenting stuff. It's already been done. So the appellate court is simply looking at the record of what happened in the trial court. So they're not looking at this fresh for the most part. They are looking at this to see if the trial court did or didn't do what it was supposed to do. So their record of what's happening would include transcripts, so they'll see what was said, but they're not going to hear new evidence. They'll see what the judge did, but they're not going to be second-guessing in many regards to that. They will simply be looking at this record. They will receive arguments from both sides, so they will do those in writing. And that's where we talk about an appellate brief. So they will submit their explanation of what went on, what the mistakes were, what the errors were, how it should be changed. And again, this is all in writing. Really, the only oral part of most appellate work is there's a very limited opportunity for attorneys representing the sides to do oral argument. In other words, to explain what they've written to the court. And very often this is just 30 minutes aside. So half hour aside to explain what we want to emphasize about the writing that we've given you, and for the justices on the appellate courts to ask questions. Okay, so very, very different functions between original and appellate jurisdiction. Again, all in writing, all paperwork on the appellate level. Okay, now we typically think of court with original jurisdiction as the trial court, and the Supreme Court, for example, is appellate jurisdiction, but this is not always the case. There are instances when a trial court could have appellate jurisdiction. How would that work? What's below? Well, one thing that's below are administrative agencies. So you might get an agency decision, and that can be appealed to a circuit court, or there may be something from a district court that could come up to a circuit court. So although mostly the circuit court has original jurisdiction, it might have a little bit of appellate. And by the same token, the Supreme Court, there are certain kinds of cases, for example, dealing with elections, requesting that a government officer be made to do something, and that case might first be brought in the Supreme Court. Now, this is a small part of what happens there, but again, we're talking about the jurisdiction, not necessarily the court. So although the trial court is usually original jurisdiction and the Supreme Court is usually appellate, we're talking about the jurisdiction or the power, not just the court. Okay, what are some other differences? Well, there's a general jurisdiction and a limited jurisdiction, and this is just like it sounds. If there's a court with a limited jurisdiction, it means it would only handle a certain kind of matter. Okay, so again, we talked about family court. There's some federal courts we'll look at in a minute that only handle certain types of matters. Okay, this is limited. A court that will handle anything and everything, or a number of things, would be a court of general jurisdiction. So in our system, the circuit courts can handle criminal, they can handle civil, they can handle a variety of matters. And there are only certain types of cases that are taken away and handled by special courts. Okay, we're going to talk about exclusive jurisdiction and concurrent. These mean just what they sound like. So if we have exclusive jurisdiction, then that means that this particular court is the only court that can handle that matter. Okay, so if it's over a certain amount, it has to go to this court. If it's under a certain amount, it can't come to this court. So it may be value or it may be type of case. Okay. Now, the concurrent jurisdiction means that there are possibility of more than one court handling it. So in Hawaii, there's a certain figure that you could take that to district court, be kind of the high end of what you could hear in a district court, or you could take it to circuit court. So if you have a choice, that means you have concurrent jurisdiction. Now, there's also some concurrent jurisdiction between federal and state. So even though we talked about two different systems, there are certain kind of case that could go either place, and we call that concurrent jurisdiction. Okay, doesn't mean you can file it two places and get the results you like. Okay, it means you have a choice of where to file. Okay, so let's take a kind of a practical look at what we're talking about. Who hears this case? Okay, this is the Honolulu Reef Runway. So you've seen this. It started out as being just some coral heads and a couple little islands. Took quite a bit of work to turn this into the long reef runway that you see here. And so during this long construction period, as you can imagine, there were some injuries and incidents during construction, as frequently happens. And the questions arose, for the injured person, where would they bring this lawsuit? Well, you may think it's kind of obvious. Well, this is Hawaii, so they go to Hawaii court. But what kind of project do you think this was? This was a federal project. So is that going to be federal jurisdiction? Other things kind of complicated it because if they're injured on the job, some of you are familiar with workers' compensation. Is this something that would be covered by workers' compensation? And again, you have state workers' compensation, you have federal workers' compensation. You also have what's called Longshoremen and Harbor Workers Act. So question is this a harbor worker? Okay. Since they're out on the ocean, there's even a possibility that this person may be considered to be a seaman. Okay, so it's maybe nautical, even though we're kind of attached to the land, maybe not. So you can see there are a variety of questions that could come up. Where do we hear this case? Okay, now, why is it important where we hear the case? Well, some of this is going to be kind of obvious to you, but let's think about that a little bit. Why do we care where? Okay, well, obviously a government and the people of a particular place have an interest in what's happening in their area. So a lot of jurisdiction is going to be geographically based. Makes sense. We are interested in what happens in our home, in our kuleana. We're also looking that the court that handles this is a court that has expertise, so they know how to handle the matter. This is the kind of cases they're familiar with. Particularly if you're talking about exclusive or limited jurisdiction, you would think that we picked this court because this court knows how to do this kind of case. Okay? Now, at the end of a case, what do we get? We get a decision, which we call a judgment, and we want to be sure when we have a judgment that we're going to be able to enforce that judgment. So we're going to want to be sure that if we have a judgment that says we're entitled to money, that the court can help us collect if the person doesn't voluntarily pay. So we want it to be enforceable. And not only the final judgment, but we may need the court's help in making the case proceed. So it may be that there are people who don't want to talk to us. We can get the court to help us. They can subpoena them. They can order them to come and give evidence. So the court needs that power and authority over the people, and it also needs it over the subject matter so that it can make sure that the court system operates efficiently and a trial or litigation proceeds in an orderly fashion. And then finally, the geographic thing again makes sense because if we have witnesses that need to appear, we want them to appear close to home. Same with the parties. So to the extent possible, it's kind of a practical idea that we should hear this in a logical place. This should be where the evidence is, where the people are, where it happened, where the situation occurred, that sort of thing. Okay, so what does a court need to exercise jurisdiction? Well, we've hinted at these previously. We need what we call personal jurisdiction, which is jurisdiction over the people. We need subject matter jurisdiction, which means the kind of case. And finally, we need to know exactly the right place, which is venue. So, again, the logic to the personal jurisdiction is we need to have control over the people that need to appear in our lawsuit. Now, if you think about it, when the person that files the lawsuit actually files the lawsuit, in essence, they're selecting the court, so they are voluntarily subjecting themselves to the jurisdiction. So they're saying, I have chosen this court, obviously I expect to be subject to the court. But the defendant, on the other hand, probably did not choose to be sued, so we need to have jurisdiction over the defendant as well, the person who the suit has been filed against. Okay, and so we would need to be able to serve them. We would need to be able to bring them into the lawsuit so that the court has jurisdiction over them as well. Okay. When we talk about subject matter jurisdiction, we're talking about the kind of case. So again, if it's a case involving federal matters, we'll talk in a minute, that would be handled in a federal court. If it's other stuff, state stuff, that would be the state court. Again, the type of case would be involved as well when we talk about courts that only handled a certain kind of case. And then finally, venue is within our court system, which actual location should the case be heard in. So federal court in Hawaii, it's easy. We have a single district. In other states that have several districts, you would select which district makes sense. Okay, we do have different circuits in Hawaii. So if a case happens on Oahu, all the people live on Oahu, that's where we'd hear it. We wouldn't end up in Hilo or Maui. Okay. Now, you probably heard the term venue with respect to change of venue, and that happens really more often probably with criminal cases. But when we're talking about a change of venue, we're talking about move it from the place that it logically would be filed to a different place. And you're probably aware of why we might do that. That would be if there's so much publicity in Oahu that the court doesn't feel like they could find jury members that don't already have an opinion and haven't already decided. They might move it to a different place where people hadn't yet formed an opinion. So you probably heard the term change of venue in that regard. Okay, now personal jurisdiction, again, power over people and parties, includes individuals, corporations, and governmental bodies, and it's within the federal district or the state. Okay, so we need to obtain personal jurisdiction, and we do that typically by serving, in other words, taking our complaint and serving it or presenting it to the people that are involved, the defendants. Okay, and that can be done a number of ways. Typically, a sheriff or process server will take it and hand it to you. You've seen this before. You've been served. And often they ask you to sign acknowledgement that you've been served. This is kind of like a traffic ticket. Doesn't mean you agree, just means you got it. And there are other ways if we can't find the person. Strangely enough, some people don't want to be sued. We can't find them. So we may need to do it by certified mail, and we may need to do it by publication. So you've probably haven't read, but have seen the teeny tiny print on the legal pages next to the obituaries. And a lot of those are summonses saying, you've been sued, this is the notice. And we're putting the notice in the paper because that's the only way we know how to get hold of you. Okay. Typically, if you're in the state, then you are subject to personal jurisdiction. If you have property here, then the court can get control over the property. And finally, if you have done something in the state, then you are subject to the jurisdiction. So we talk about the long-arm statute. What that means is even if you're not a resident or citizen of the state may be able to reach outside the state and exercise jurisdiction or power over you. So the long arm is simply a word picture of reaching outside the state and grabbing somebody and bringing them within the power of the state. So why would we do that? Well, that would be minimum contacts, something that has occurred that gives the state the power to bring you back. Okay. What could those be? That could be something like you've committed a tort, you've injured somebody here, you were a tourist, rented a car, struck somebody, or you did business in the state. So those are minimum contacts. Those are activities that bring you within the purview of state of Hawaii system. Okay. So we want to give notice to the defendant that they've been sued. This gives them an opportunity to defend themselves, considered to be part of due process. Again, we talked about service, which is actually getting the lawsuit to the person, giving them notice. Okay, another type of jurisdiction is subject matter jurisdiction. So we talked a little bit about family, probate. These courts may be handled separately. And another part of subject matter jurisdiction that may not be obvious is we're talking about the value of the case. So we think certain courts should handle certain types of cases with respect to value. So we talked about small claims where you don't even need an attorney. We have district courts, which are the smaller matters. Then there's an area that kind of the top of what you might take to district court, or you may decide to go to circuit court. So there's some that could go either place, in other words, concurrent jurisdiction. And then over a certain amount has to go to circuit court. So there are those kind of limitations. And we'll see in a little while, federal court has a limitation going the other way. In other words, we're not going to allow this kind of case unless it's worth more than a certain amount. So we're not going to deal with the small stuff. So the amount in controversy can also be part of what we call subject matter jurisdiction. Okay, and venue, as we said, was an appropriate place. This is a real practical kind of thing to have convenience of the witnesses, convenience of the parties. It makes it efficient for the court. Again, logically, if a situation has occurred, normally that's going to be the place we look. So that's where all the witnesses would be, the evidence would be, that sort of thing. But there may be other factors we consider at venue as well, and we'll talk briefly about that with respect to both state and federal. Okay, so again, now we come to the choice. So we've said federal or state, and remember, easiest thing is to look at the more limited jurisdiction. So we'll look at federal jurisdiction. We'll determine whether or not it's a federal matter. If not, then it's a state matter. So that's really our first cut. That's the first thing we look at. So again, federal court is limited jurisdiction. We have two kinds of jurisdiction in the federal court. One is called federal question, and one is called diversity. You can see that the federal question jurisdiction is the exclusive jurisdiction. In other words, these kind of cases are only going to be heard in federal court, and the other kind of cases are concurrent. The diversity cases are concurrent. That means they can be heard in federal court or state court. Okay, so the federal question cases deal with actions arising under Constitution, law, or treaties. So what does that mean in a practical sense? Okay, well, federal law is going to be enforced in federal court. They're not going to have the majority of federal laws are not going to be looked at over in state court. Now, again, certain areas, special education, welfare, there are both state and federal laws, so there may be some application there. But it's up to the federal government as to where they're going to be handled. Okay, so other types of cases that we would handle in federal court, federal employees, if it happened on federal property, those are all going to be handled in federal court. Okay. Now, just to give you an example to make it a little clearer, I always say, remember your ABCs. Okay, so what in the world does that mean? Okay, well, we're a maritime place, the ocean, so we have maritime law, but we typically refer to that as admiralty law. So admiralty law is going to deal with cases that happen on the high seas that involve the water, the oceans, etc. This is an area of federal law. So an admiralty case is a federal case. It uses some archaic language. It's interesting, you may have heard the term before, where they can arrest a ship. We typically think you only arrest people. No, in admiralty you can arrest a ship. Okay, so what are we going to have for B? Something happening more and more these days, unfortunately, bankruptcy. So bankruptcy is a federal case. If you go to bankruptcy court, you have gone to your federal district court, and that handles your bankruptcy. Same across the country. Okay, and finally, C is copyright. So our intellectual property, for the most part, is going to be federal. So patents, copyright, a fair amount of trademark stuff is all going to be federal law. Okay. C could also maybe have been civil rights. A lot of the civil rights law is federal, although, of course, we have that state as well. Okay, so the diversity jurisdiction, not federal question. This is a different kind. Federal question exclusive. Diversity is concurrent. This is historical. Originally, the states did not trust each other, so they did not want to handle matters between different states in a particular state's court. So the federal system will handle that if it's between different states or countries and if the value is greater than $75,000. So this has gone up. Started out $10,000, $50,000, $75,000. And presumably if the courts feel like too many cases coming in this, then they'll raise that level again. Okay, this one last thing about the federal court and the diversity jurisdiction that's kind of interesting is a process called removal. So as we said, concurrent means that this kind of case between citizens of different states worth a certain amount could be handled in federal court. Well, there's no reason it couldn't be handled in state court either. That's what we mean by concurrent. And this is an instance where if I filed a lawsuit as a Hawaii citizen against a New York corporation and it's worth more than $75,000, then the defendant could decide they want to be in federal court, because federal court also could have jurisdiction. And they can simply elect, they can choose to have that case taken over to federal court. This is unusual. This is the only instance where you filed in the proper court and they're moving you to a different court. Normally, you file in the right place, you stay there. So this is rather unusual. Okay, what is the purpose? Again, this is simply where you think you'll get a better deal in federal court for whatever reason. You don't want to be sued. You don't want to have your case heard in a court that's related to the person who sued you. So I'm an out-of-state corporation. I think I might get a better deal if I'm in federal court than in Hawaii court. Okay, venue, similar between federal and state court. Again, we mentioned these. Logically, it's going to be where the claim arose. If that isn't determinative, then we'll look where the defendants reside, where the property exists. And in federal court, if nothing else fits, then wherever we can get hold of the defendant. Okay, hard to see, but just wanted to show you briefly the circuits. So Hawaii has 4 circuits, 1, 2, 3, 5. Whoops, what's that about? Well, Big Island used to be 2 circuits. It's now a single circuit. So first circuit is Oahu. Second circuit is Maui, Molokai, Lanai. Third circuit is Kauai, Niihau, and Fifth circuit is Big Island. Okay, so summary of jurisdiction. Jurisdiction cannot be conferred by the parties. In other words, you can't agree to have it someplace. It has to be where the court has authority. Once you have jurisdiction, then you will be able to stay there, with the exception of the removal that we talked about. And then if you get a judgment in Hawaii, you can enforce that judgment in a different state. So the full faith and credit between the states means that your judgment can be enforced in a different state if the defendant leaves. Okay, I want to talk briefly about suing the government. Government establishes rules for suits involving it. So we'll mention this down the road a little bit, but if you sue the government, be aware that the government limits how it can be sued. So they might restrict your jury, they might restrict the time you have to file, and they may exclude certain kinds of remedies that you would be able to get against a private citizen because it's the government and they set up the rules. Okay, we will be talking in the future about the difference between substance and procedure. So substance of the law is just the subject matter. In other words, is this a contract? What do we need to have a contract? What are the elements? So that would be substantive law. But equally as important, particularly in litigation, is going to be the procedure. In other words, how do we file a lawsuit? What are the time limits? So the how-tos. So we'll be looking at both substantive, the subject area, and we'll be looking at the how to handle it. Okay, procedure is generally the area that the lawyers take care of. So for the most part, as an individual or a business person, you're going to be more interested in the subject matter, but you will need to get help in the procedure because this takes the specialist. And finally, we'll be looking at some other issues involved in litigation. So we've talked about filing, where to file, the jurisdiction. There's some limits on when to file. These are called statutes of limitation. There are limits on who can file what kinds of suits. So it may be talking about standing. There are certain things that there aren't remedies for, unfortunately. So there may be that you feel you've been wronged, but a person has not violated any kind of statute, so you may not have a remedy. So we'll be looking in the future at the various possibilities of what you need to file, how you file, etc. And so we'll be looking at some court cases, and that will, and court procedure, and that will give you an idea of how litigation fits into how you do business and your other affairs. Okay, so we got a good background now on the court system. Next time around, we're going to look actually at a lawsuit. We're going to get a better feel for exactly how legal action happens, because, of course, you're going to want to stay out of lawsuits as much as you can, but you need to know what happens if you don't. So it's kind of preventive maintenance and understanding how that process works. Okay, so this has been Carroll with Business Law 200, and I'll see you next time. Aloha.